resettled in their place of origin. The appointment of the Presidential Task Force for Resettlement, Development and Security in the Northern Province was a key initial policy decision taken to spearhead the resettlement, reconstruction and development drive in the Northern Province. Within this overall context, the government embarked on the lessons learned in Reconciliation Commission, a domestic mechanism in order to strengthen the national reconciliation process and to ensure the dividend of peace to all Sri Lankans. The government continues with the implementation of the reconstruction of the NLRC, and after 144 recommendations contained in the 50 and 88 recommendations, which have long-term implementation time frames, are well underway. The Special Bureau for Reconciliation, which I represent, seeks to facilitate and coordinate this process and to ensure that efforts at reconciliation remain coherent and coordinated. It will also serve as a platform to demonstrate commitment to reconciliation and inter-ethnic harmony and national unity through a trust mechanism for rebuilding the confidence among communities. It will also assist the line ministries and agencies vested with the responsibility of effectively implementing and monitoring the respective recommendation assigned to them in the National Plan of Action. A joint need assessment was co-designed by the government and the UN Humanitarian Country Team as a joint task. The JNA was a multi-sectoral needs assessment seeking to identify sustainable livelihoods, recovery and development needs of the resettled and remaining displaced persons in conflict-affected districts. It reviews sectoral areas presented in the data and present where these achievements have been made. It also presents opportunities and areas that needs further assessment. The report of the JNA is now being completed. Mr. Chairman, I wish to say that the government of Sri Lanka considers reconciliation as a multifaceted process and also context-specific. We firmly believe that our efforts in achieving reconciliation through a holistic approach would contribute significantly to realize the objectives of achieving durable solutions for those concerned in the northern and eastern provinces of our country. Our approach has already contributed to the realization of not only the developmental objectives, but also ensure socio-economic, cultural, civil and political rights of the people while securing right to life free from terrorism through a forward-looking domestic framework. Thank you, Mr. Chairman.
Thank you, and we conclude the summary of presentation.
And I thank the delegation for those presentations on behalf of the committee. We now move directly to colleagues' follow-up questions to the state's responses. As is our wont, we will do it in two rounds. The first round will be issues 1 to 13, and the second round will be, you guessed it, 14 to 26. So starting with issues 1 to 13, I'm going to give the floor to colleagues. And the first speaker on my list is Mr. Iwasawa. You have the floor, Mr. Iwasawa.
Thank you, Mr. Chairperson. I join you in extending a very warm welcome to the distinguished delegation of Sri Lanka, headed by Excellency Ambassador Arya Sinha. I thank the distinguished delegation for the fifth report. The committee considered the last report in 2003. The fifth report was submitted 5 years later than requested. Nonetheless, we welcome this opportunity to resume a dialogue with the state party. We are pleased to have a substantial delegation before us today, and take note that it is composed of various qualified members from different departments of the government of Sri Lanka. I thank the distinguished delegation for submitting written responses to the list of issues in advance and summarizing them orally now. They form the basis upon which we will ask further questions today and tomorrow. Sri Lanka is a party to many of the core UN human rights treaties. We commend the government of Sri Lanka especially for the fact that it ratified the optional protocol to the covenant in 1997, while many Asian states have yet to become its party. I must point out, however, that the committee has serious concerns about the cooperation of Sri Lanka in individual communication procedures, an issue to which I will come back later. At the outset, I want to recognize that Sri Lanka has had difficult times, in particular during the armed conflict with the LTTE, which continued for nearly 3 decades. Sri Lanka has undergone major changes in the 11-year period since 2003, when the committee considered its last report. It transitioned from a ceasefire to intensive armed conflict with the LTTE. After the fighting ended in 2009, Sri Lanka has been faced with post-conflict challenges, including reconstruction, reconciliation, and accountability. The committee is concerned about human rights violations that may have been committed by any of those involved in the conflict. Justice, accountability, and reconciliation must be secured for all Sri Lankans. Another major concern the committee has is the state of rule of law in the state party. I take note with pleasure that Sri Lanka has many active civil societies. Activeness of the civil societies is an indication of the society's openness and democracy. In the last session, the committee appointed a special rapporteur on reprisals because it takes the issue of reprisals very seriously. I expect the state party to share the same commitment. We look forward to having a frank and constructive dialogue with the distinguished delegation on the human rights situation in Sri Lanka today and the ways in which it can be improved. This afternoon, I will ask questions on issues numbers 1, 2, and 3. So I start with issue number 1. As Ms. Tilena Latine stated, the Supreme Court of Sri Lanka held in 2008 that the Constitution and other laws in Sri Lanka give adequate recognition to the rights contained in the covenant. On the other hand, however, the National Action Plan, approved by the Cabinet of Ministers in 2011, recognized shortcomings in Sri Lankan law and proposed a constitutional amendment to ensure the right to privacy, the right to information, and the right to life within 1 year. Could the distinguished delegation explain what actions have been taken with regard to this proposal of the Cabinet of Ministers? In 2008, the Supreme Court held also that the rights in the covenant are justiciable and that individuals derive the benefit and guarantee of rights in the covenant through the medium of the legal and constitutional process in Sri Lanka. But Sri Lanka follows the dualist approach, and the covenant has not been incorporated and has no internal effect in Sri Lanka. The ICCPR Act of 2007 gives effect only to Articles 14, 16, 20, and 24 of the covenant. Could the distinguished delegation clarify how the rights in the covenant under these circumstances are justiciable in Sri Lanka? And I acknowledge that the Supreme Court of Sri Lanka relied on the covenant to give a purposive meaning to the provision of the Constitution and other laws in the past. However, in 2006, in the Singarasa case, the Supreme Court ruled that Sri Lanka's accession to the covenant was in violation of the Constitution. According to information before us, Since this decision, the covenant has had little effect in Sri Lanka. And because the independence of the judiciary has been undermined in the meantime, the Supreme Court no longer is likely to engage in creative interpretation of the Constitution. Could the distinguished delegation comment on this report? Another issue I would like to raise at this point is the principle of non-discrimination and the rights of non-citizens. In the previous concluding observations, the committee stated that it remained concerned that some covenant rights are denied to non-citizens without any justification. Could the distinguished delegation respond to this concern of ours? I'd like to turn now to the issue of implementation of the committee's views in individual communication procedures. In the Singarasa case, the Supreme Court ruled not only that Sri Lanka's accession to the covenant was in violation of the Constitution, but also that the committee's views are not binding in Sri Lanka. And since that decision, the state party has not been cooperative in the individual communication procedures, not replying to allegations by the author and failing to abide by interim protective measures requested by the committee. The committee has adopted 14 views with respect to the state party, finding its violations of the covenant. I take note with regret that the state party has not implemented those views, and that state party also fails to cooperate with the committee in its follow-up procedure. I am bound to express our disappointment at the state party's lack of cooperation in individual communication procedures, and would like to point out that under the optional protocol, which the state party ratified in 1997, it has a legal obligation to cooperate in the individual communication procedures. Could the distinguished delegation explain why the decision of the Supreme Court in the Singarasa case prevents the government from cooperating in the individual communication procedures? I now move to issue number 2 and start with questions on the 18th Amendment of the Constitution. The 18th Amendment did away with the Constitutional Council, a multi-party body to ensure independence of key oversight bodies, and empowers the President to appoint unilaterally justices to the Supreme Court and the Court of Appeal, Attorney General, and individuals to oversight bodies such as the Human Rights Commission of Sri Lanka. According to information before us, the executive's control of independent bodies was further exacerbated when institutions such as the Attorney General's Department was moved from the Ministry of Justice to be under the direct control of the executive. Could the distinguished delegation respond to the allegation that the 18th Amendment has made appointments to key oversight bodies politicized, and that these bodies are no longer independent of the executive? It seems to us that the 18th Amendment has severely undermined the independence of the judiciary in particular. This issue will be taken up further by another colleague tomorrow. This afternoon, I will focus upon the Human Rights Commission of Sri Lanka. The ICCPR Act of 2007 provides that the High Court may refer a matter arising under the Act to the Human Rights Commission for an inquiry and report. Has such a reference ever been made? According to information before us, the Human Rights Commission of Sri Lanka was downgraded to B status by the ICC in 2007 for failing to comply with the Paris Principles, after the President of Sri Lanka began circumventing the Constitution by making direct appointments to the Commission, despite a legal requirement that appointments be made by a Constitutional Council. Other concerns which have been expressed about the Human Rights Commission include its financial independence, its limited mandate, as well as its lack of timely action with complaints made to the Commission. Could the distinguished delegation explain what steps it plans to take in order to make the Human Rights Commission of Sri Lanka compatible with the Paris Principles and to have it regain A status? Draft legislation to amend the Human Rights Commission Act in order to strengthen its powers and mechanisms have been sent to relevant stakeholders for their observations. Could the distinguished delegation explain what changes the amendment will introduce, and when is it expected to enter into effect? I now turn to issue number 3. According to your written replies and your summary, 97% of the 12,000 former LTTE combatants have been rehabilitated and integrated into society. According to other information before us, however, those who surrendered for rehabilitation were detained and interrogated, and in some cases even killed or became missing. Could the distinguished delegation comment on such allegations? And according to your written replies, the Bureau of the Commissioner General of Rehabilitation is engaged in coordinating with relevant institutions to ensure the socio-economic reintegration of ex-combatants. We would appreciate it if you would give us your assessment of the activities of the Bureau. I take note that the government of Sri Lanka has spent 2.5 billion rupees on the rehabilitation of former LTTE cadres, and in 2013, it increased the allocation from 300 to 500 million rupees. According to information before us, however, the former combatants who were detained in the protective accommodation and rehabilitation centers are not provided with useful training or counseling and are subjected to lengthy interrogation. Could the distinguished delegation comment on such allegation? Could you please explain how the protective accommodation and rehabilitation centers are supervised? I would like now to address the issue of freedom of movement of the former combatants. The written replies claim that there have not been any reports of any type of diminishing of mobility of the former combatants by surveillance and monitoring by the security forces. According to other information before us, however, persistent surveillance, intimidation, and monitoring of the former combatants by the security forces continue to restrict their freedom of movement and association, and has inhibited them from reintegrating into the social and economic life of their communities. Could the distinguished delegation comment on such allegation? I look forward to receiving replies from the distinguished delegation and having a frank and constructive dialogue. Thank you, Mr. Chairperson.
Thank you, Mr. Iwasawa. Next speaker on my list is Mr. Flinterman. Mr. Flinterman, you have the floor, sir.
Thank you, Mr. Chairman. Like my colleague, Mr. Iwasawa, I very much appreciate this opportunity to resume the dialogue with the distinguished delegation of Sri Lanka, and I therefore join him in warmly welcoming the delegation. The questions that I am going to raise are all related to the twin core principles in the field of human rights, the principle of equality and non-discrimination, or to say that in other words, the principle of inclusiveness. Human rights are there for all, no one accepted. And that brings me to the issues number 4 to 7. I was pleased to note that the delegation emphasized today in its oral presentation again that the prohibition of discrimination against women as contained in the legislation of Sri Lanka is fully in line with its obligations under Article 1 of the CEDAW Convention. But I'm very much aware that Sri Lanka presented its combined 7 and 8 report to the CEDAW Committee in 2011, and that at that time the CEDAW Committee, our sister treaty body, highlighted a number of concerns and also made a large number of recommendations. I'm not going to echo all of those concerns here and neither all of the recommendations, but I would like to focus on a number of relevant issues in this respect. First of all, my question would be to the distinguished delegation whether in Sri Lanka there is a comprehensive strategy in place to modify or eliminate practices and stereotypes that discriminate against women. And I'm raising that particular question, Mr. Chairman, echoing CEDAW, but also because we have information about before us about stereotypical thinking and attitudes of high-level politicians, including ministers. Let me give you one example, and I quote, "Women should not be appointed to responsible positions of public office because by nature they are unable to get on with each other and constantly fight and slander each other," end of quotation. If such stereotypical comments are made, what can be expected from the government in order to eliminate practices and stereotypes discriminating against women? My second question would be what exactly the legal status is of that women's charter adopted by the cabinet in 1990. Is that still in force? What is legal status? What remedies are available under that women's charter for women trying to uphold their rights? What exactly is the mandate of the National Commission on Women's Rights, in particular the Complaints Center within that National Commission on Human Rights? And we have information before us that recently a very interesting initiative was taken by the introduction of a Women's Bill of Rights to Parliament in 2013. But that particular Women's Bill of Rights has been withdrawn. Could the delegation, distinguished delegation, give us further information on the status of that particular bill? I just referred to the fact that that at high-level positions there is stereotypical thinking. Well, I would like to pinpoint that and express my concern, like CEDAW did, on the extremely low level of women's participation in political affairs. Out of 132 countries in the world, the International Parliamentary Union has ranked Sri Lanka as number 125 as to the representation of women in Parliament. There are only 13 female members out of a total of 225 members in Parliament. And my question to the delegation would be, what steps, including temporary special measures, is the government envisaging in order to increase the participation of women in political decision-making? I haven't found, neither in the report nor in the replies, a clear answer to the question how women participate in the post-conflict reconstruction and peace-building processes. I do appreciate the examples that have been given of a number of programs that are certainly beneficial to women in this situation. But what I would like to have is whether the information that is before us is correct, that there is no female representation in the Presidential Task Force for the Resettlement, Development and Security in the Northern region. And that brings me to issue number 4B. The issue number 4B, where I was pleased to read that the marriage registration ordinance has been amended and that now the minimum age of marriage in Sri Lanka has been set at 18 both for women and men, and that the marriage registration ordinance is also prohibiting polygamy. But like CEDAW did in 2011, I would like to raise the issue of the lack of such a minimum age requirement in the Muslim personal law, and also the fact that under that particular law, polygamy is still allowed. And my question would be to the delegation whether any amendments to the Muslim Marriage and Divorce Act are being considered by the committee which is chaired by a Supreme Court judge, and whether that particular committee includes representatives of the Muslim community, including also female representatives, and whether any time frame has been set for the amendment of the Muslim Marriage and Divorce Act, and whether, and that was a suggestion by our sister treaty body, so far any attention and any consideration has been given to a unified family code. I further would like to raise the question about some other discriminatory laws, laws that discriminate against women, which have been brought to our attention, especially in the field of land rights, such as the Land Development Ordinance, the Kandyan Law, and some other laws. And my question is, what time frame is in place in order to also address and withdraw such laws that discriminate against women? And that brings me to issue number 5, another aspect of the equality principle relating to the rights of LGBT. I was at the same time very much pleased and disappointed by the very short reply that was given by the state party to the issue raised on the protection of the rights of LGBT people. I was very pleased because I read that the government, that the state party, is explicitly recognizing that Article 12 of the Constitution of Sri Lanka is also relevant for the protection of the rights of LGBT, that the equality principle, without explicitly mentioning sexual orientation as a ground of discrimination, is interpreted by the state party as also covering discrimination on the basis of sexual orientation. And I would like to commend the state party for taking that position. And if that's the case, I think that an obvious question would be what steps the state party is considering to make this implicit widening of the scope of Article 12 explicit by amending Article 12 of the Constitution so as to also include sexual orientation as an explicitly mentioned prohibited ground of discrimination. But at the same time, I was somewhat disappointed by the short answer because it seemed as if the scope of the problem of discrimination against LGBT people in the context of Sri Lanka was not fully appreciated by the government in its replies. Because we have information in front of us from which it appears that both in law and in practice, LGBT people in Sri Lanka are often discriminated. I would like to refer you to your penal code, Article 365A of the penal code, but also to that ordinance dating back to the colonial times of 1842 the vacancy ordinance, which are used to criminalize same-sex sexual conduct. I would like to refer you to the practices of arbitrary arrests and detention in Sri Lanka against LGBT people, and to the failure which has been brought to our attention of the state party to protect LGBT people against violation of their rights, both in the public and in the domestic spheres. And for that reason, apart from expressing once again my deep appreciation for the interpretation given to Article 12 of the Constitution, is what steps the state party is considering in order to address in practice and in a practical manner the discrimination of LGBT people by, for example, withdrawing the discriminatory provisions in your criminal law. And that brings me to issue number 6. That's the issue relating to violence against women, including domestic violence. And once again, as was noted today by the head of delegation, Mr. Ambassador, I was very pleased to note that in 2005, Parliament passed the Prevention of Domestic Violence Act. But at the same time, that's just another example in general that in such fields, the adoption of a law is one thing, but very important as well is the implementation of the law. And in issue number 6, our committee raises the issue on the basis of information before it that despite the Act of 2006, which should be commended, violence against women remains a widespread problem, and that impunity in this field still prevails. And I think that the replies given in to the list of issues do not address that issue. Is it a lack of awareness of women, of their rights under the Constitution and under the laws of the land? Is it the lack of training of law enforcement officers? Is it the attitude of political leaders that is hampering and creating obstacles? And we have information before us, Mr. Chairman, that leading politicians in the country have said that some laws, and there was an explicit reference to the Prevention of Domestic Violence Act, some laws are introduced from the West, and such laws are excessive and do not conform with the culture in Sri Lanka. And I found that expression interesting, that violence, I quote, violence in the home is only until the rice is cooked. An interesting expression. My question to the delegation would be, what steps is the state party considering to combat violence against women in all its forms and to adopt legislation, to adopt comprehensive legislation, including violence against women, including the issue of rape? And my concrete question added to this is whether the state party, because we haven't got an answer to that, whether the state party is considering to extend the criminalization of marital rape regardless of judicial acknowledgement of separation. And then finally, I come to question number 7, and that relates to cases of rape and other acts of sexual violence that occurred during and after the conflict. And the replies to that particular question provide only some information. And I'm not clear, I would like to invite the distinguished delegation to have a look at its replies to issue number 7. I'm not clear exactly which period the reply covers. And secondly, whether the reference to a slight increase in the numbers, in the number of cases of rape, which period that particular slight increase refers to, and neither do I understand exactly the information that is given to us about the progress of cases which period that covers. We are informed that so far 5 out of 39 cases of rape are being prosecuted. That's only 12%. And my question there would be, is that compatible with the obligation of the state party to promptly investigate, prosecute and punish such crimes? We have information before us, Mr. Chairman, from recent reports that indicate, that show that there is an escalation of violence against women, especially in the north and east. And I'm here referring at the invitation of the delegation to a report of the International Crisis Group of 2011, and that sexual violence against war widows and single women has increased, and that former female combatants have been harassed and abused, and that women have been intimidated and moreover, that there is a lack of psychosocial care for women. My question to the delegation would be to shed some more light on this particular issue by giving more detailed information, and in particular, how the state party has addressed the findings that have been highlighted in the report that I've just referred to. And there I end my questions for today, Mr. Chairman. Thank you very much.
Thank you, Mr. Flinterman. The next speaker on my list is Mr. Newman. Mr. Newman, you have the floor, sir.
Thank you very much, Mr. Chair. I'd like to add my warm welcome to the distinguished delegation, to thank them for the answers given to the list of issues. And I look forward to discussing the ways in which the protection of civil and political rights in Sri Lanka can be improved. I'm happy to observe that Sri Lanka acceded to the covenant without any reservations, and is therefore fully bound by all the requirements of the covenant. I'm responsible for only one issue today, issue number 8, which asks about counterterrorism regulations under the Prevention of Terrorism Act, which replaced the emergency regulations after the end of the armed conflict. The committee certainly deplores all the abuses committed by any party to that conflict, but the conflict ended in 2009. In June of 2010, the state party withdrew most of its derogations from the covenant, in light of the fact that the emergency that had justified them had ended a year earlier. Nonetheless, the state party maintained its derogation from Article 9, Paragraph 3, a very important protection for the liberty of detainees suspected of criminal offenses and for the prevention of mistreatment in custody. Excuse me. How does the distinguished delegation justify the continuation of a derogation when there is no emergency? The distinguished head of delegation referred in his opening statement to the possibility of a resurgence of terrorism. A possibility is not a permissible basis for a derogation. Even if a derogation were permissible, how do the derogating measures regarding detention under the Prevention of Terrorism Act regulations satisfy the standard of Article 4 of the Covenant, which requires them to be strictly required by the exigencies of the situation? The Prevention of Terrorism Act is not just being kept formally in case of a future resurgence, but it is actually being used. New detentions continue to occur, and allegations of torture of persons being detained under the Prevention of Terrorism Act continue to be raised. There are also allegations of use of the Prevention of Terrorism Act to detain human rights defenders, including in some widely publicized cases. As I understand the law, the courts have no authority to review the actual need for detention under the Prevention of Terrorism Act, or whether that detention has lasted longer than necessary. May I ask, how is this consistent with the covenant? The risk of mistreatment is even greater in PTA detentions because the PTA reverses the burden of proof and requires the accused to prove that a confession was not voluntary. This committee has already explained that that reversal violates the covenant. Indeed, what legitimate justification could there be for reversing the burden of proof when the detainee was in the power of the government and the government has superior access to the evidence? There are also reports that habeas corpus is not effective as a remedy in PTA cases because cases are not decided without delay, as Article 9, Paragraph 4 of the Covenant requires them to be. Because detaining officials do not cooperate, and because the Attorney General often transfers cases to locations where it is difficult for the petitioners to litigate them. Regarding statistics on habeas corpus, which were requested in the list of issues, I thank the distinguished delegation for the information that there are 133 habeas corpus cases pending. But the committee would like to know how many habeas corpus cases have been filed seeking release from security-related detention, and in how many of those cases the courts have actually granted release. Have there been any cases which have been completed and led to the release of the detainee? Finally, may I ask the distinguished delegation, when will the special detention regime under the Prevention of Terrorism Act be repealed? Thank you very much, and I look forward to the answers.
Thank you very much, Mr. Newman. The next speaker on my list is Ms. Seibert-Flohr. Ms. Seibert-Flohr, you have the floor. Ms. Seibert-Flohr, you have the floor, ma'am.
Thank you, Mr. Chair. As my colleagues before, I would like to extend a warm welcome to the distinguished delegation, and I look forward to having a fruitful dialogue. The questions that I will ask today are related to the protection of the right to life, which is indeed a major concern, particularly enforced disappearances and extrajudicial killings. There is prevalent information indicating that enforced disappearances and extrajudicial killings were not only committed during the time of the conflict until 2009, but continue to be a serious problem in the state party. As evidenced by the latest report of the working group on enforced and involuntary disappearances, there are not only 5,731 outstanding cases, but also new disappearance cases, which have been transmitted to the state party. Though the state party rejects allegations that it is responsible for enforced disappearances and extrajudicial killings, it gives several examples by itself, such as the indictment of several police officers, including inspectors in charge of a police station for abduction and murder. There are allegations that persons were abducted after the end of the conflict and brought into the custody of the Criminal Investigation Department, where they were interrogated and allegedly tortured. There's also information indicating that the military, the police and paramilitary groups under the control of the armed forces are involved in enforced disappearances. Such disappearances are commonly referred to as white van abductions, a pattern in which political activists and journalists who are critical of the government are abducted and later often found dead. So my questions are as follows. What steps have been taken to stop these kinds of abductions? What are the procedures and the institutional mechanisms in place to actively investigate the whereabouts of missing persons? Are there any official statistics on disappearances? We are aware of the Presidential Commission on Disappearances, which is competent to investigate disappearances which took place between 1990 to 2009. to which the head of the delegation referred in his opening statement. But is it also competent to investigate disappearances outside the northern and eastern province, for example, abductions which have occurred in Colombo? How about the follow-up? Has the Commission or any other investigating commission advanced substantiated cases of abductions or enforced disappearances for the investigation by the appropriate criminal bodies? Have perpetrators been sanctioned and victims or their family been compensated? It seems that the safeguards in place are insufficient to prevent such crimes in the first place. One important step would be to recognize the right to life, as the head of the delegation pointed out, the most important right in the text of the Constitution. This committee already in its previous concluding observations noted with regret that the Constitution of the State Party does not expressly provide for the right to life. Though the Supreme Court considered it to be protected by implication under Article 13, paragraph 4 and Article 11 of the Constitution, this interpretation seems to be insufficient, especially given the prevalence of extrajudicial killings. Considering the magnitude of the problem, I was troubled to read in the replies by the State Party that the State Party claims to be free in the implementation of the right to life. However, if a right is not effectively implemented, it is necessary to look to the legal safeguards and to recommend constitutional changes. Furthermore, the absence of a criminal provision criminalizing enforced disappearances seems to be a contributing factor to continuing disappearances. The State Party replies suggest that there is no need to amend the criminal law. But I have learned from the website of the Justice Ministry that a section on disappearance for the Penal Code has been drafted. Therefore, I would like to ask for the current state of this amendment. In addition to legislation, investigation and prosecution are important elements for the protection of the right to life. However, there are allegations that investigation into disappearances and killings are insufficient. This also applies to death in detention. There's information that at least 6 persons died under unclear circumstances in police custody between November 2013 and May 2014. I would like to ask the distinguished delegation to please describe the procedure and the relevant legal basis for the investigation of death in custody. Which independent institution is in charge of such investigations? Could you please provide us with statistics on the number of deaths in detention and the respective outcomes of the investigations? To be more concrete, what steps have been taken to officially and independently investigate the use of force by the army in the riots of the Velikada prison in November 2012, which reportedly resulted in the death of 27 prisoners? What are the obstacles which prevented the investigation in the Vavunya prison incident of June 2012 to establish criminal responsibility for the death of 2 inmates? I was troubled to read in the replies by the State Party that there are not too many cases ending up in convictions which the State Party tries to justify with the adversarial system of criminal justice. But this does not relieve the State Party from its obligation to properly investigate and to pursue criminal cases with an intent to bring those responsible to justice. Of course, there is no guarantee for a conviction, and the right to due process needs to be guaranteed. But the low indictment and conviction rate suggests that the investigation and subsequent proceedings may not be conducted with an intent to hold perpetrators accountable. I will now turn to maternal mortality and abortions. The committee, again, in its previous concluding observations, noted with concern that abortion is criminalized except when the life of the mother is at stake. There is no exception for therapeutic reasons and in cases of pregnancy resulting from rape or incest. Could the distinguished delegation update us on the current efforts by the Ministry of Child Development and Women's Affairs to amend the penal code and on the work of the consultative committee? What is the result of the consultation process that the state party has to refer to in its replies? And when can we expect an amendment to be introduced? This committee has expressed concern about unsafe abortions before. There's information indicating that 10% of maternal mortality is caused by clandestine and unsafe abortions. It seems that in particular teenagers and women in less developed regions are affected because of lacking access to contraceptives and limited information on reproductive health. So my final questions are here. What steps have been taken to identify the reasons for and prevent maternal mortality? What measures are in place to improve access to contraceptives and to provide information and education on reproductive health and family planning in all regions of the state party? This brings me to the end of my questions for today, Mr. Chair. I look forward to the answers by the distinguished delegation, and thank you.
Thank you, Ms. Seibert-Foer. The next speaker on my list is Mr. Shani. Mr. Shani, you have the floor, sir.
Thank you, Mr. Chair, and I would like to join my colleagues in welcoming the delegation of Sri Lanka and its renewal engagement with the committee. I'm going to be dealing with issues number 11, 12, and 13, all dealing with the matter of accountability. I realize that some of the issues that we'll be discussing are sensitive and that there are very different factual narratives. We as a committee, we are equipped with limited fact-finding capabilities and cannot reach any independent conclusions on some of the specific allegations as to what had happened during the Civil War, and particularly in the last stages of the Civil War. We can, however, and we must, in fact, evaluate the degree in which the state party has complied with the covenant requirements pertaining to its duty to investigate allegations of serious human rights violations by all parties to the conflict, to prosecute those responsible for any violations, and to ensure effective remedies for victims. And we can also evaluate the extent to which the state party is effectively addressing what potentially could be ongoing violations attending to cases of disappearances. I should emphasize upfront that we are not dealing here only with the events of 2009, but rather with what are alleged at times to be chronic problems of law enforcement and accountability in Sri Lanka. Our committee has already criticized in its individual communications the manner in which allegations of torture and disappearances were handled by the Sri Lankan legal authorities in the Satasivam in Saraswatika's case, as well as the Sarma case. Moreover, it has been claimed before us that the findings of the 2006 Presidential Commission of Inquiry, which looked inter alia into the 2006 killings of 17 local staff members of a French NGO, SCF, in Mutar, were never published. The question that I have to the delegation in this regard is whether this is true, whether the findings have never been published, and whether the delegation can update us as to whether any measures were taken in connection with these investigations, as in fact was recommended in paragraph 5.163 of the LLRC report. In the same vein, with regard to the 2006 Commission, were any of the concerns that were raised by the International Independent Group of Eminent Persons, the Darusman Committee, the International Independent Group of Eminent Persons, about the independence and impartiality of the 2006 Commission, ever addressed? Now, as for the 2009 event, we mentioned in the list of issues two investigations into the relevant events: the Secretary General's panel of experts report and the UK Channel 4 series of broadcasts on the final month of the Civil War. And I would like to pose some specific questions on these two investigations, or two sets of findings. With regard to the Darusman report, it is not clear from the 2011 LLRC report why were the factual findings of the panel of experts report disputed by the Commission. I did read the Minister of External Affairs statement of 28 April 2011, which described the panel's report as fundamentally flawed and biased. The question I have is whether, notwithstanding any criticisms that the state party has vis-à-vis the panel of experts report, whether the specific factual findings of the panel, such as those pertaining, for instance, to conditions in the Menik farm and allegations of torture that were perpetrated there, or with respect to the shelling of the P2K hospital on every day between 28 January and 4 February 2009, which were a version of events which was largely corroborated by the LRC report. Have these specific allegations been thoroughly investigated by the state? So the question is whether, regardless of the overall evaluation of the strength of the panel report, were the specific findings, allegations thoroughly examined, and if refuted, on what evidentiary basis? Similarly, with respect to the Channel 4 broadcasts, can the delegation describe whether if any investigative steps were taken by the Army Court of Inquiry to investigate the allegations raised in the documentaries? Again, putting aside any controversy surrounding the authenticity of some images or sounds contained in the broadcast, they do present very concrete allegations about shelling of civilians, for instance, in the NFZ by army forces in deviation from the president's zero civilian casualty policy. Also included specific allegations of extrajudicial executions and sexual assaults against women. And the question that I pose to you is whether, again, these specific allegations were investigated, and what were the outcomes of these investigations, and whether anyone has been prosecuted on either side as a result. Specifically also with regard to the Court of Inquiry report, is it true that this report has not been put in the public domain? And if so, why not? And in any event, has there been any follow-up to any of the findings of the COI? Now, the broader concern we have here is whether the state party has adopted what the UN panel of experts called a restorative justice approach, which omits an individual accountability component even for serious international crimes allegedly committed by combatants of both sides to the conflict. And my question in this regard is whether the delegation can explain to the committee what is the state party's current position on the need to balance between accountability and reconciliation. While it appears that much effort has been put by the state party into the post-LLRC investigative operations in the context of the National Plan of Action, we have not received any concrete data on actual prosecutions that have resulted from this process. Can the delegation please respond to allegations as to the adequacy of the main investigative mechanisms that were introduced by the state party and that were raised by the UN panel of experts? For example, allegations concerning lack of independence of some members of the LLRC, given their past affiliation to the government, the scope of the mandate of the LLRC, which lacked a sufficient focus on individual accountability, and lack of adequate resources that would have allowed the LLRC to conduct a full investigation of alleged violations of international law, and finally, the lack of a witness protection program. Can you also, in the same vein, respond to concerns about the independence and impartiality of the COI process, given that its members were appointed by Lieutenant General Jaya Surayanoyor, who was responsible for planning of the operations in the Vani? While we welcome the establishment of the Disappearances Commission and the appointment of a high-level international advisory board, as well as the extension of the temporal mandate of the Commission, we hope to receive from the delegation further updates on the work of the Commission, and in particular clarifications on whether, after the expansion of the mandate of the Commission, whether the new timeline for reviewing the large number of complaints that it has received, and in addition, reviewing the other components of its expanded mandate within the new time frame, is this a realistic project? Just to remind ourselves, there, according to the website of the Commission, there have been almost 20,000 complaints which have been filed by the to the Commission, and it is scheduled to finish its work by mid-February 2015. This appears a very unrealistic timeline for a serious investigation of these claims, not to speak of the additional questions that were now referred to the Commission. Can you also, with respect to the disappearances investigation, can you also address concerns with relation to the involvement of the military in the conduct of the disappearances investigation? For instance, is it true that the military is responsible for registering complaints to the Commission, and whether any witness protection measures have been put in place in advance of the passage of the new witness protection bill in Parliament? Is the government willing to reconsider its position with respect to cooperation with the new fact-finding committee that was set up by the Human Rights Council? While states are not under a strict legal obligation to cooperate with all procedures of international investigation, it is a sign of good faith and certainly a sign of good practice for states to do so, especially when states may be under resource constraints in conducting their internal investigations, and given some of the concerns which I've already alluded to, raised against the independence and effectiveness of these internal investigations. And finally, on this aspect, can you explain what measures, if any, Sri Lanka has taken to deliver justice for victims of the civil war? There appears to be a reparations program that has been introduced under the National Plan of Action, but it would be, I would welcome any information that the delegation can provide to us as to how many individuals have obtained relief through that program, and to what extent. Now, with respect to, I just covered issues 11 and 12, and I have just a few more observations and questions with relation to issue number 13, dealing with the implementation of the LLRC report. It is our understanding that the National Plan of Action seeks to implement about half of the 285 operative paragraphs of the LLRC report. Can you explain to the delegation how were the operative paragraphs to be implemented selected, and by whom, and whether there have been any operative paragraphs containing substantive recommendations that were not selected for implementation? Is it feasible to implement all of the 144 recommendations selected within the allocated time frame for the work of the National Plan of Action? While the serious effort by the government of Sri Lanka to deal with so many recommendations in such a short time span is certainly commendable, the level of detail promulgated by the progress reports of the National Plan of Action mechanism so far published is quite limited, and leaves quite a lot to be desired. And I would welcome the delegation's observations on the matter. For instance, the latest report mentions that investigations into conscription of child soldier, recommendation 9.79, has been completed. But the report doesn't mention what does it mean that the recommendation, that the investigation has been completed, and had any legal proceedings been initiated as a result of these investigation? What were the conclusions of that investigations? Or in the same way, recommendation 914 addresses reparations, but again lacks details about its implementation. So at the end of the day, more than 5 years after the war has ended, we are not certain. We still don't have a complete picture as to whether and to what extent the responsibility of perpetrators have been thoroughly explored, whether individuals have been put to justice, and whether reparations have been paid. And this lack of information about accountability does not sit well with a strong commitment to principles of both accountability and transparency, which serve as the bedrock for any post-conflict human rights-based strategy of response. I thank the delegation in advance for its responses, and I apologize for the length of my intervention. Thank you.
Thank you, Mr. Shani. That's the last of the speakers on the list I started with. If no colleague is seeking the floor, no other colleague is seeking the floor, I'm going to suspend the meeting for 15 minutes to allow the delegation a little time to concert and organize the distribution of replies. 15 minutes allows time to organize distribution, perhaps, rather than content. Pardon, j'avais pas vu que Monsieur Benachou.
Mr. Benachou has asked for the floor. I apologize. I hadn't seen that. Thank you, Mr. Chairman. Very rapidly, after thanking the esteemed delegation, and welcome to our committee, to return to the questions asked earlier by Professor Rivas Agua on the 17th and 18th Amendment of the Constitution of Sri Lanka. Let me remind everybody that under international law, states must prosecute perpetrators or suspected perpetrators of grave violations of human rights and take them to court. However, in the Constitution of Sri Lanka, Article 35, paragraph 3, gives a virtual total immunity. The speaker feels there is no interpretation. Could we please have somebody indicate whether the English is coming through? In the Constitution of Sri Lanka, Article 35, paragraph 3, grants virtual full immunity to heads of state, that is, the president. And so my question is as follows. According to the delegation, is this article consistent with the principles of international law? Thank you. Thank you, Mr. Benachou. Are there any further requests for the floor?
Wanting to speak? If not, then I do now suspend the meeting for 15 minutes to allow the delegation to concert to organize the distribution of its replies. We meet again at 5:10. Welcome back, distinguished delegation, colleagues. We resume the 3098th meeting, and the delegation is now going to respond to the first round of questions from colleagues, again relating to the issues 1 to 13. So I hand over the conduct of the proceedings now again to the head of the delegation for him to distribute responsibility as he sees fit amongst his colleagues. Ambassador, you have the floor.
Thank you, Mr. Chairman. First of all, I want to thank members who addressed issues relating to Sri Lanka. We very respectfully take the comments you have made, and as you know, we have given you a very detailed answer to the broader issues, and on most of the specifics, we would endeavor to reply in this session, and if not, we will do so in writing by Friday. Today, to start with some of the questions, particularly covering questions 1, 2, 4b, and 5, I once again would like to call on Additional Solicitor General Bimba Jasingha Tilakaratna to take the floor.
Mr. Chairman, with regard to the clarification sought by the learned member from Japan, I would like to state that the application, the constitution and legal framework within which the covenant is implemented right to an effective remedy, whether there is constitutional legal framework to give effect to the provisions in the covenant. The application of the ICCPR was a subject of Supreme Court determination, as I explained before. In this instance, the specific questions, two specific questions were directed to court. They were whether the legislative provisions cited in the reference that have been taken to give statutory recognition to civil and political rights in the International Covenant on Civil and Political Rights of the United Nations adhere to the general premise of the covenant, and whether individuals within the territory of Sri Lanka would derive the benefit and the guarantee of rights as contained in the covenant through the medium of the legal and constitutional process prevailing in Sri Lanka. That was the first question placed before court. And the second question was whether the said rights recognized in the covenant are justiciable through the medium of legal and constitutional process prevailing in Sri Lanka. Then court held that as stated in the preamble to the covenant, the rights recognized and enshrined therein stem from the Universal Declaration of Human Rights. As a basic premise, the fundamental rights declared and recognized in Chapter 3 of the Constitution are based on the Universal Declaration of Human Rights. The court cited Article 40 of our Constitution and held that the fundamental rights declared and recognized by the Constitution form part of the sovereignty of the people and have to be respected and secured and advanced by all organs of the government. This was the court's opinion, a unique feature of the Constitution which entrenches fundamental rights as part of the inalienable sovereignty of the people. Thus, fundamental rights acquire higher status as forming part of the supreme law of the land and cannot be abridged, restricted or denied except in the manner and to the extent expressly provided for in the Constitution itself. So it was noted that the court has permitted public interest litigation, as I mentioned before, covering matters of transcend the infringement of individual rights. Directions have been issued in connection with matters of general importance as to liberty, personal security, administrative action connected with a wide variety of matters, the impact on the natural environment, particularly with regard to water, air, and noise pollution. So we have a lot of cases in the category of public interest litigation where court has upheld the right of individuals. The court also emphasized that Parliament enacted special legislation titled International Covenant on Civil and Political Rights, which I referred to earlier, Act number 56 of 2007, to give legislative recognition in respect of any residual right and matters in the covenant that have not been appropriately contained in the Constitution and the other operative laws. So, if the Constitution and other legal provisions do not cater to all the rights in the covenant, the residual rights are also brought in under this particular act. So that shows that all the rights in the covenant are now justiciable. Furthermore, it was observed that Supreme Court and several decided cases relied on the provisions of the covenant to give a purposive meaning to the provisions of the Constitution and other applicable law, so as to ensure to the people that they have an effective remedy in respect of any alleged infringement of rights recognized by the Constitution. The court has held in the case of Veeravansa versus Attorney General, Sri Lanka is a part to the covenant, and a person deprived of liberty has a right of access to the judiciary. That has been recognized by the Supreme Court. The court noted that Article 27 of the covenant makes a specific reservation that in states in which ethnic, religious, or linguistic minorities exist, persons belonging to such minorities shall not be denied the right in community with other members of their group to enjoy their own culture, to profess and practice their own religion, or to use their own language. In the view of the court, it could not be contended that the provisions of Article 16(1) of the Constitution that only provides for the continuance in force of the already operative law could be considered to be inconsistent with the covenant only on the ground that there are certain aspects of personal law which may discriminate women. The matter of personal law is one great sensitivity. The covenant should not be considered as an instrument which warrants the amendment of such personal laws. If at all there should be any amendment, such request should emerge from the particular sector governed by the particular personal law. With regard to the optional protocol to the ICCPR, Sri Lanka, having acceded to the optional protocol of the ICCPR, had set in motion procedures to implement the views of the committee until the Supreme Court judgment in the case of Nalaratnam Singarasa versus Attorney General. In this case, 5 judges of the Supreme Court held that the government of Sri Lanka, by acceding to the optional protocol to the ICCPR, had violated the provisions of the Constitution, and only courts and tribunals set up under the Constitution can vindicate the rights of the people of Sri Lanka. The government of Sri Lanka informed its position to the Human Rights Committee and the Office of the High Commissioner for Human Rights. This matter is currently receiving the attention of our courts in CA Writ 697 of 2010. The government of Sri Lanka will inform the committee of the outcome of the case. As regards question number 2, raised by honorable member from Japan, I would say regarding the 18th Amendment, I must say in terms of the 18th Amendment, the composition, manner, and functioning of the Constitutional Council was changed. It was changed, and it became known as a Parliamentary Council after the 18th Amendment. According to the amendment, the Parliamentary Council will consist of the Prime Minister, the Speaker, the Leader of the Opposition, a nominee of the Prime Minister, who shall be a Member of Parliament, and nominee of the Leader of Opposition, who shall be a Member of Parliament. The chairman and members of the committee referred to in Schedule 1 and the persons to be appointed to the offices referred to in Part 1 and Part 2 of the Schedule 2 of the amendment shall be appointed to the commission and the officers referred to in the said schedule by the President. In making such appointment, it is incumbent upon the President to seek the observations of the Parliamentary Council, consisting of the measures I referred to earlier. Thus, a mandatory process of consultation which the President has to undertake has been introduced by the 18th Amendment. One has to bear in mind that there were infirmities in the 17th Amendment that impacted upon the operationalization of bodies such as the Election Commission. Even the Constitutional Council could not be constituted because there was no agreement among minority parties on the composition. The legislature recognized the... Okay, okay. The legislature recognizes several... You have to go slow?
Yeah, go slowly.
Okay. The legislature recognizes several weaknesses inherent in the 17th Amendment, among which the principal critic was its non-workability, as I said before, and the 18th Amendment was a legislative response to cure the infirmities that had rendered the Constitutional Council non-workable. The fact that several commissions and high officers that were operationalized since the 18th Amendment and the robust functioning today demonstrates the efficacy of the 18th Amendment, and now it has strengthened the process of governance. It has to be pinpointed that the Supreme Court of the country had declared this amendment to be constitutional before it was enacted by Parliament. As regards the question raised with regard to Human Rights Commission, in terms of Section 15 of the Human Rights Commission, any authority or person to whom a recommendation has been made is required to report to the HRC of the action or proposed action taken to give effect to the recommendation of the Human Rights Commission. If any authority or person fails to report to the Commission of the action or proposed action to give effect to the recommendation, or it is the view of the HRC that action taken is inadequate, the HRC is required to submit a full report of the facts to His Excellency the President, who shall cause such report to be placed before Parliament. In addition to that statutory requirement, the Ministry of Public Administration issued a circular number 17 of 2005 to all public institutions, directing them that they should take necessary action to implement the recommendation of the Human Rights Commission. In the event they are unable for good reason to implement such recommendations, they are obliged to inform the Human Rights Commission of such reason. Then the steps are being taken to further improve the Human Rights Commission Act in order to strengthen its powers and mechanisms. Has been sent to the relevant stakeholders for their observations. So it's underway. Those are my reply to section question number 1 and 2. Then Ambassador
4B and 5.
You will take
4B and 5. 5 you can take.
5. Yes. May I be permitted to answer the question raised with regard to question number 5 also about this LGBTs. Article 12(1) of the Constitution of Sri Lanka provides that all persons are equal before the law and are entitled to the equal protection of the law. Article 12(2) of the Constitution ensures that no citizen shall be discriminated inter alia on the ground of sex. In this context, it must be noted that laws discriminatory of a person on the grounds of sexual orientation would not be constitutional. However, noting the concerns expressed by some parties regarding provisions 365 and 365A of the Penal Code, it must be stated that the said provisions are not utilized to target any particular group, but to preserve public order and or morality. That's enough. Huh? You are taking 8? Or 4B?
4B and 8.
Yes. Out.
May I introduce
Mr. Narin Pulle.
now I will invite Deputy Solicitor General Narin Pulle to answer section 4B, question 4B, please.
Thank you, Ambassador. Mr. Chairman and members of the committee, I would take this opportunity to respond to the questions posed under question issue 4B and 8. I would take them in sequence. The there was a pointed question, several questions formulated under the context of 4B, and I think it would be apt for me at this point to make a reference to the content of the marriage registration ordinance as amended, which governs marriages between parties other than the Muslim community, and which provide for the following. Because there was a specific question in the context of the amendment to the Muslim Marriages and Divorce Act, which is being considered by a committee headed by a Supreme Court judge. In this regard, I think I would draw the attention. I'm diverging from the main content that I was proposing to make to address that particular question as well. Now, in that context, there's a committee headed by a Supreme Court judge considering amendments to the Muslim Marriages and Divorce Act. And in that regard, I think with great respect, I would draw the attention of the committee to paragraphs 131 and 139 of the state party's response, which I believe would elaborate, but I think any further questions on that could be also responded to in the form of a written form if necessary, considering the time constraints that we are having at this point, because I think there is comprehensive answers to be given to several of the issues that were raised. But having said that, I will now turn to the provisions of the marriage registration ordinance, because this is, I'm making reference in context of the specific issues under issue 4B. In the context of the provisions of the marriage registration ordinance as amended, as I said, which governs marriages between parties other than the Muslim community, the following should be noted. I think that's very important that you take cognizance of these factors. In terms of section 18 of the ordinance, no marriage shall be valid where either of the parties thereto shall have contracted a prior marriage which shall not have been legally dissolved or declared void. Therefore, it confirms to the fact that polygamy is prohibited. In terms of section 15 of the ordinance, no marriage shall be valid unless both parties to the marriage have completed 18 years of age. In addition, the provisions of the Penal Code provide special protection to the underage by imposing criminal responsibility and punishment upon breach of certain provisions of the Penal Code, in particular, section 363E of the Penal Code. I think that's a point that one needs to take note of. Now, in order to eradicate underage marriages, the National Child Protection Authority, which is known as the NCPA, has conducted awareness raising programs aimed at rural youth and has used electronic and print media in this context to send messages across the communities. The NCPA has also requested the Registrar General to take steps to confirm the age of marriage of the female party before registering a marriage by perusing the identity card or birth certificate, as the case may be, and action has also been taken to prosecute underage couples who have taken such courses of action. In addition, as I observed at the outset, amendments are also underway, have been considered with regard to proposed amendments to the Muslim Marriages and Divorce Act, and I think the committee would be appraised of future developments in that regard by the government at the relevant time. Now, that was in response to the issues raised under issue 4B. Now, I might turn to a response which I would give, and in this context, I think the response I would share with my colleague Shashikala Premwardana from who is present here. I would just briefly outline certain measures that have been taken in the context of counter-terrorism, because there were several issues raised in that context. Now, I must say at the outset that all detainees can challenge the lawfulness of detention by way of habeas corpus in the High Court or the Court of Appeal, and also challenge such detention in the Supreme Court by way of a fundamental rights application. And I must say that this is a very provision that is used quite often, and we have a series of cases. I mean, we could give you the statistics of those, because there's a large number of cases filed on a daily basis if and when there are concerns. The Supreme Court entertains such applications, and it's not confined to habeas corpus applications itself. So there was an observation made about habeas corpus. I must very categorically say that fundamental rights jurisdiction is a jurisdiction available to any person in Sri Lanka who alleges any such violation with regard to detention. as regards the fundamental rights application, it's noteworthy that complaints could be initiated by even addressing a letter to the Supreme Court, which we call the epistolary jurisdiction, which has been developed by the Supreme Court, as Learned Senior Additional Solicitor General pointed out in the context even of the ICCPR. I think that is one form of jurisdiction that our courts have shown judicial activism, and it's a clear jurisdiction because today we have a provision through judicial activism where we have recognized public interest litigation, and that is a jurisdiction that has been as observed even in the ICCPR opinion expressed by the Supreme Court. The Supreme Court has now recognized that jurisdiction within the context of our constitutional framework. So that is, I think, a point which needs to be taken note of. Then we have, in this context, I must also say that the government of Sri Lanka continues to review the cases of suspects held under the Prevention of Terrorism, the PA Act, which we, in order to prosecute and submit to rehabilitation or release persons held in detention upon a consideration of the evidence. So that is a process. I think there was a very specific observation made in that context by the Senior Additional Solicitor General in a presentation with regard to that particular aspect where the Attorney General deals with this aspect of rehabilitation. Pardon me if I'm taking too much of this thing, but I think this is something which we need to address because I think there was a specific observation made in that context. Now, with regard to the PTA and its compatibility with the provisions of the covenant, might I at the outset say this. Although a confession made to a ASP or Assistant Superintendent of Police was admitted under the emergency regulations, those regulations have since been repealed in August 2011. And I think Ambassador brought that point very clearly in his presentation, and I think I must reiterate that fact. Now, though a confession made to a police officer is admissible under the Evidence Ordinance, under the Prevention of Terrorism Act, such confessions are only admitted if the court is satisfied beyond a doubt after what we call a voir dire inquiry. Now, that is a procedure that is inbuilt within our judicial structure, and that is something which is followed very strictly with regard to the voir dire inquiry, that such confessions were made voluntarily. So that safeguard is adequately covered through our judicial processes, and that has been there right throughout the process of the application of the Prevention of Terrorism Act. Now, the burden of proving the ingredients of an offense is always on the prosecution. That is a standard requirement. Now, it is only with regard to confessions under the PTA that the burden shifts to the accused to show that it is admissible under Section 24 of our Evidence Ordinance. Now, under Section 24 of the Evidence Ordinance, a confession made by an accused person is admissible in criminal proceedings if the making of the confession appears to the court to have been made under inducement, promise, or threat. Is inadmissible if the making of the confession appears to the court to have been made under inducement, promise, or threat. This reversal of burden of proof, I would say, is a universal phenomenon, and examples are galore of such provisions in common law jurisdictions. Now, Sri Lanka being a common law jurisdiction, this is something which is provided for. I must say that in the context of Article 13(5) of the Constitution is emblematic of this universal practice when it states, I quote, every person shall be presumed innocent until he is proved guilty, provided that the burden of proving particular facts by law be placed on an accused person. So our Constitution itself has provided certain procedures with regard to this aspect. Now, the voluntariness of making confessions and its truth are benchmarks that are taken into consideration before a court would admit a confession against an accused. Thus, it can be asserted that none of the provisions of the PTA are offensive of the Convention. Now, this is our position, and I think that is in accord with the, as I observed, with the common law jurisdiction and the universal the practices that we have seen in common law jurisdictions. Now, the PTA is a special law enacted by Parliament to deal with matters relating to terrorist activities. Persons are arrested under the provisions of the PTA are entitled to all safeguards, including visits by family members, attorneys at law, magistrates, medical officers, members of the clergy, representatives of the ICRC, and the National Human Rights Commission, which I think was a point very clearly set out by Senior Additional Solicitor General in the context of dealing with that particular, the summary which dealt with that particular aspect. Now, might I just also make a point of the fact that since the end of the conflict in 2009, the Attorney General has made, in many instances, opted to rehabilitate the suspects as an alternative to prosecution. This is in line with the policy of restorative justice followed by the government. Now, rehabilitation is conducted only in instances where the suspect voluntarily agrees to rehabilitate himself before reintegration into society. So this is something I think which should be taken note of. And I would say that we have had over 200 persons recommended by the Attorney General for rehabilitation in lieu of prosecution after 2009. So this, I think, is a feature which needs to be taken note of, that this is a role that the Attorney General plays with regard to this particular aspect. This process is also facilitated through courts and under judicial supervision. In addition to recommendations for rehabilitation made by the Attorney Generals, the court has also in many instances sent convicted persons for rehabilitation as a substitute for jail sentence. So notwithstanding the nature of the offense, these are certain procedures that have been followed in our judicial system, which I think needs to be taken note of. So in that context, I must say that the writ of habeas corpus is yet another remedy guaranteed under the Constitution to protect the liberty of persons. So that this means the liberty of persons is not merely guaranteed only through habeas corpus. We have a very robust fundamental rights jurisdiction in our country. So I think it's apt for me at this point to refute any allegation that there are ineffective measures with regard to habeas corpus, because there are currently, as it was pointed out, 133 cases pending in courts throughout the country, and of course the judicial process will follow its course and come to conclusions in accordance with the legal procedures set in place. Now, in that context, now having set that tone of the content of our procedures that we follow under the Prevention of Terrorism Act, I think in the context of the resurgence of terrorism, which was articulated by my ambassador, I think I would turn to my learned colleague on my left to take you through certain concerns that we have in this context and enlighten you on some of those aspects. Might I just hand over to my colleague to address you on those particular aspects of concern.
May I introduce Ms. Sashikala Premawardana, Senior Assistant Secretary of the Ministry of Defence and Urban Development, please.
Thank you, Ambassador. I'm just going to try and explain some details and provide some details with regard to certain incidents that have happened since the end of the conflict with regard to a possible resurgence of terrorism in Sri Lanka. Now, although the government has militarily defeated the LTTE, its overseas network, which includes a number of trained cadre funded by some sections of the expatriate Tamil community, continues to remain in place, as was explained by my ambassador. As you would be aware, India, USA, EU, as well as many other countries have continued to keep LTTE on the proscribed terrorist list. The recently concluded, released EU Terrorism Situation and Trend Report 2014 of the Europol observed this. LTT networks remain in numerous countries and continue to attempt to rebuild their structures and operating capabilities, especially via fundraising and money laundering. It notes that in Switzerland, for instance, police continued to investigate the activities of a number of former LTT members. The investigations focus primarily on operations aimed at channeling funds collected on Swiss territory to Sri Lanka. This is the EU Terrorism Situation and Trend Report 2014 of the Europol. The information that we have is that there are a number of cadre, both in the country and outside, who have evaded arrest and who have not undergone a rehabilitation process. Furthermore, the security forces continue to recover buried arms caches. ammunition, explosives, and equipment. Such items may be accessed by residual carders or self-motivated carders who could prove to be extremely dangerous. There is evidence that members of some of these groups operating from overseas are trying to regroup, having established contacts with local elements to carry out acts of sabotage and terrorism to disrupt peace and stability in the country. Several incidents, I want to explain several incidents that have taken place during the past, which have positively established the connections between the LTT remnants in Sri Lanka with those operating from overseas. In 2012, LTT cadres operating on the instructions of operatives in France, basically Kumaran under instructions from Vinanagam, leader of the LTT HQ group, carried out an assassination of a member of a political party, the EPDP, in Trincomalee, Sri Lanka. This was an initial indication that the LTT was regrouping to carry out acts of violence in the country. Subsequently, further evidence emerged of a network of connections stemming from Europe, Malaysia, India, and Sri Lanka of LTT operatives attempting a resurgence of terrorism. In March 2014, the government of Sri Lanka took measures to list 16 entities and 424 persons under UN Security Council Resolution 1373 who were believed on reasonable grounds to be attempting to commit, facilitating, or participating in the commission of acts of terrorism. This order designating entities and persons was undertaken following several years of consideration of information and monitoring of activities of the listed entities and persons. The substantial effect of an order under Regulation 1373 is that funds, assets, and economic resources belonging to or owned by the designated persons or entities remain frozen until they are removed from the designated list. There have been several actions by law enforcement authorities, both in Sri Lanka and in friendly countries, before as well as after GOSL action under UN Security Council Resolution 1373. Based on information received, a combined operation was launched, this was in 2012, by Indian and Sri Lankan authorities, which resulted in the arrest of connected LTT operatives in Chennai, December 2012. The group in Chennai had been found providing training to make improvised explosive devices to youth, ex-LTT cadre coming from Sri Lanka. These were clear indications of LTT's new efforts. In March 2014, as we noted in our statement to the 25th session of the Human Rights Council, investigations confirmed that there were coordinated efforts by a broader network of LTT operatives functioning from overseas. 3 LTT operatives, Gobi, Theivan, and Appan, who were overseas and had returned to Sri Lanka, were found to have been actively involved in reorganizing the LTT in the north. They were involved in the recovery of LTT arms, cash, re-establishing the LTT intelligence network, recruiting unemployed youth and rehabilitated LTT cadre, and collecting information on potential VIP targets, including in other provinces, with the intention of carrying out terrorist acts in the country. Investigations revealed that funding for such activities came from Europe and were being transferred using Hawala, which is an illegal system of money transfer. It was also revealed that many safe houses, vehicles, and other resources required for the resurgence of LTT had been procured by them using this money. While these operatives were killed during a search operation in the Vanni region on 11th April 2014, this incident highlights the very real dangers that exist for Sri Lanka in this regard. In May 2014, the Malaysian authorities took action at the request of Government of Sri Lanka to extradite 3 key LTT operatives arrested by the Malaysian authorities, who are wanted in relation to terrorism-related offenses in Sri Lanka. All of the above attempts suggest that the LTTE international network is active and is making every possible effort to revamp its military capability in Sri Lanka. The government has been providing information regarding these activities to our counterparts and will continue to do so, particularly following the listing of the UN Security Council Resolution 1373. And we stand ready to provide any further information on issues and incidents outlined in my intervention. Thank you.
Mr. Chairman, my colleagues have very comprehensively dealt with both the legal aspect as well as the practical aspects in answer to Commissioner Newman's question as to why the PTA is still in existence. I would like to address the direct question you asked, which is when will it end? The question of when a terrorist legislation ends is a good question. When terrorism is recognized as a problem and action is taken as far as legality is concerned and when it begins is also a very important question. I think the Chairman this morning drew attention to what he called brazen challenges. It is fortunate that what is happening in parts of Syria today and Iraq today, in Iraq and Syria today, we are taking note of it. We are exercising remedies for it. We are coming together. But we in Sri Lanka, when terrorism began in the 1980s, it was not until 1992, when Sri Rajiv Gandhi, the former Prime Minister of India, was killed, that the world started recognizing the LTTE and its ferocity. It was not until in 1996 that the US banned the LTTE that the Western world recognized it. It was only after 2001 that actually this question got attention. So therefore, my submission, Mr. Chairman, is that countries have to act within the law, but proportionate to the challenge and the threat. I would submit, as my colleagues have detailed, that the issue here is that is the action which Sri Lanka is taking right now proportionate? And this was a question, Mr. Chairman and Commissioners, we had to answer at each step post-conflict. When the IDPs were kept in the camps, the question was asked. It was said that they would never be allowed to go, that their rights were going to be violated. It was very publicly said. But within a couple of months, they started going out. And within about 2 years, they were all resettled. What was it? Yes, there was a risk. There was a risk that if you let these people out, and some of them you hadn't even identified as ex-combatants, that they would start trouble. But the government of Sri Lanka took that risk. That was a considered choice. Then, once again, we had the whole question of ex-combatants. And when the ex-combatants issue came up, again this question came. In fact, I remember in the European Parliament once a member of Parliament asking me, but Ambassador, isn't this dangerous? I said, yes, but it is a calculated risk you've got to take, because rehabilitation within government institutions is one thing, but society probably is the best place where people can get rehabilitated. Once they go there, they have problems there as well, because within those societies, you're shunned. So I think when you take the question of whether or not Sri Lanka retaining the PTA is fair, you have to take into consideration that this is not only a government which does so because it has problems with these people still, because there is legal framework, but it is a problem that this is a government which has taken choices. It has allowed ex-combatants to go. It has out of about little over 12,000 ex-combatants, some 500 child soldiers were sent to their parents almost within 2 months. We only have to be reintegrated into society 112 males and 2 females who are undergoing rehabilitation. Now, I think it is very important that this be taken note of. When you look at PTA, it is because we feel that there is a reasonable concern. And I think this is true not only of Sri Lanka. If you take other countries in the world which have faced terrorism far later than we have, their legislatures, their law is in place. I'm sure it is correct for you to ask them the question, when will these laws end? But as states which are responsible for human life, as I said earlier, the right to life, I think if one is aware that there is danger, we need to be cautious. And I must also add that in 2010, just a year after the conflict ended, we allowed the emergency to lapse. Now that was something which at that time many felt was too fast, but Sri Lanka did it. So my point on this is that when Sri Lanka is asked to do things, please be conscious that we are also conscious of the responsibility which we have to act with. But we have to do that with the responsibility to all parties. And in this instance on the PTA, we reluctantly have to keep it because we feel that the challenge and the threat continues. I thank you.
Thank you, Ambassador. Do I take it that concludes the responses?
I think, sorry? Okay, we'll finish this.
I'm afraid we do, since it's just about to become 6 o'clock, but I just wanted to clarify at what stage you were, so that there's just one small thing outstanding, which we'll start with tomorrow, and then we can go to follow-up questions. And
yes, I think also 13, we've got to come back to 13.
Okay, so...
And sections of 9, I think. Huh? Sorry? Yes, and sections of, that was 9, right? Panel of experts.
So
we will come back to those questions.
So a few things first thing tomorrow, and then we'll move on. Okay, thank you very much, Ambassador. Thank you to the whole delegation for your explanations. We look forward to more explanations and further exchanges tomorrow morning. I wish you all a very good and pleasant evening, and meeting you all refreshed tomorrow at 10 o'clock. The session suspended.